senior consultant at Click Law Partners. He has been representing a group of victims of Cyprus property mis-selling for the past 5 years. The group has gained widespread support, and even opponent banks and the developers now recognise that Click Law Partners is the firm they need to deal with if matters are to be resolved. Thank you for agreeing to give us an interview, Mr. Kounis.
You're welcome.
How did you first get involved with the group?
I was a senior consultant at Maxwell Solicitors when a victim of mis-selling contacted us to see if we could help. Victims were attracted by my approach, and the group grew since by word of mouth.
I'd like to discuss what you and the group are trying to achieve.
In simple terms, we're trying to resolve these cases either by reaching a satisfactory settlement in each case or by group litigation.
What are the pros and cons of litigation and settlement?
If you pursue litigation and win, you may recover your losses plus costs from your opponents. However, there is no certainty in litigation, and even if you win, you will probably recover less than 70% of your legal costs. Furthermore, litigation could drag on for many years, particularly if a judgment is appealed. An out-of-court settlement will not give you everything you want, but may give you a satisfactory resolution to end early closure so that you can get on with your life.
So, how does one decide?
The client would need to consider the settlement terms being offered in his or her case versus the litigation risks and costs.
So, are you suggesting that victims need to choose one or the other?
On the contrary, you need to run both concurrently until you either settle or go to trial. Just as you are assessing litigation risks, so are your opponents. Litigation pressure has to be there to achieve the best possible settlement.
What is the current state of proceedings?
I would say that victims can be categorized into 3 areas. Those who are not involved in litigation at all because they have not filed a claim or they're not being sued by the bank in Cyprus. Those with litigation in Cyprus, and those litigating in England as part of a collective action in the High Court. The jurisdiction of the High Court over these cases has been challenged by the opponents. However, victims expect a favourable outcome at the jurisdiction hearing, which has now been set for the 11th of June 2018.
Can you give us an update on your settlement negotiations?
Initially, the banks were not willing to negotiate at all. Then they offered to write down part of the losses on foreign currency loans only. This offer was not acceptable to many of our clients because the properties lost up to 70% of the original purchase price, which was the main loss. They could not get the anticipated rental income. The balance was inflated by excess interest and foreign exchange losses, and they would be left in a substantial negative equity. The banks have now come down to try to recover the value of their security, plus whatever they can get on top from each client. This is unacceptable to most clients, particularly those who have paid large deposits, incurred other costs, and made repayments. So you might ask, where do we go from there? Our solution is a universal settlement.
What is a universal settlement?
Universal settlement aims at the closure of all cases in a single agreement. It does not mean one size fits all. On the contrary, it addresses each and every case so that individual terms are satisfactory enough to be agreed by all. Litigants are attracted to a settlement because it replaces the uncertainty of litigation with the certainty and finality of a settlement.
How can you convince the banks to buy into this?
The bank's rate of recovery is dependent on how much they can recover from the properties they hold as security, how much they can get on top from each client, and how much it will cost them and how long it will take to recover that money. By removing the risk of losing at trial and having to pay out and not spending time and money chasing, they can lower their overall expectations on each case and still recover more in total.
So, how are you proposing to proceed?
We have proposed that the universal settlement may work better for the bank by giving them immediate recovery across the whole group instead of individual recovery, which would take them much longer with doubtful results. Secondly, give them potentially better property values through participation and market control, and the elimination of the risk of litigation.
Can you give us an example?
Let me run you through a possible scenario to illustrate that it's all about maximizing the value of the asset so that the overall losses and demands are minimized. Let us take 3 properties purchased for €100,000 each. In a depressed market, they can probably realize 30,000 each, but in an open market, 50,000 each. The bank's approach is to realize the value of these properties at 30,000, less costs, which would leave them with 25,000, say, per property, and pursue victims for more. But at best, they can pressurize 1 out of 3 victims to give them more. So 1 victim may give them 15,000. The other 2 are either refusing to pay, do not have any money to pay, or worse still for the bank, taking them to court and demanding money from the bank by way of compensation. If all 3 victims were to cooperate in maximizing the value of these properties, the realizable value of the properties would be 150,000. The deficit would be smaller, and the disputed amounts between litigants would be far less. Everybody wins when you think this through. The difference between the case-by-case and the collective approach is huge. Under the first, everyone loses. Under the second, the losses are minimized.
Why do you say that this is better for all victims?
Victims are trying to minimize the negative equity they have suffered. Banks are trying to maximize the amount they recover from each victim. The collective approach means that first, the banks will recover more overall than chasing each victim separately, and victims will minimize their losses by reaching a settlement instead of spending time and money fighting the banks. Second, the larger the group, the better the deal will be for victims, because the banks are being asked to look at overall recovery, whereas the victims would be pooling their resources to reduce the average burden on each of them. Third, by being part of a larger group, victims are posing a serious litigation threat to the banks. Furthermore, if a universal settlement is reached and the litigation threat is removed, individuals that are outside the group and smaller groups will be picked on, and the banks will be demanding maximum recovery from each of them. They have no litigation protection. Our invitation is open to everyone to join us as individuals or groups to achieve the best possible universal settlement, or ensure that if it has to go to court, as a group sharing the costs, victims are empowered to take on the banks.
What if you do not reach an agreement?
Litigation always remains an option, and is the reason we need to ensure that we do everything possible to be ready for it. The larger the group, the greater the chances of success, whichever avenue we pursue.
What about victims who have done nothing? They say the banks have left them alone for nearly 10 years. Why would they bother now?
I believe that banks are currently concentrating on low-lying fruit. Banks do not write off debts without first ensuring that they have not left a stone unturned. Faced with having to write off substantial amounts, they will act probably by getting a judgment in default, registering it, and then enforcing. Ignoring the legal process is never a good idea, and by the time a defendant realizes that he should have acted, it is too late. The bottom line is, do you want a nightmare hanging over you for another 10 years, or would you prefer a permanent solution so that you can get on with your life?
Can you tell us if you've had any success yet?
Yes, indeed we have. Where clients needed to settle now and could not wait for the universal settlement, we have settled. Clients have been forced to settle either because they were sued before they came to us, or by pressing personal reasons necessitating an early settlement. Although we believe we can achieve better results by reaching universal settlement, even on a case-by-case basis, we have been able to wipe out a significant amount of the negative equity. For some clients, the banks have written off over €1 million.
Can you still offer help to victims?
Our motto, strength in numbers, has never been more relevant. The group can help you, and you can help if you join. An increase in our numbers will give us the best possible settlement, the strongest possible litigation fund, and reduce the share of the burden on all victims of the group. Time is running out. The inevitable conclusion is that once a universal settlement is concluded with our group, it will be much harder for any group not posing a serious litigation threat to get a good settlement. This, therefore, may be the last opportunity to settle on attractive terms. Please encourage as many victims as possible to join.
Mr. Kounis, thank you very much.
You're very welcome. Thank you.